our session on AI and regulation. My name is Roxana Mihetz. I'm an assistant professor of finance at the University of Lausanne and a faculty member of the Swiss Finance Institute. And I've been co-organizing this really interesting session together with Christian Peukert, who is a professor in the Department of Strategy at the University of Lausanne, and together with Suzanne Vergnolle.
Yes, I am a postdoctoral fellow at the Swiss Institute of Comparative Law and at UNIL. We thought it was important during a 5 days conference on AI and machine learning to have the legal and policy perspectives, and we believed it was crucial to bring that discussion during our session. And I'm going to be inviting our three amazing speakers on the floor to start the session already.
So the way we have it organized, in the first part, we'll have a legal panel on the legal implications of AI regulation. And then in the second part, we'll have a panel on economics and finance. So without further ado, welcome. And we look very forward to a very interesting discussion. Thank you.
So again, thank you for being here. We're going to start our first panel session with three presentations, very short presentation, 10 minutes, and then we're going to do a panel discussion with our three speakers who you will see have a very insightful perspectives. They have very different background, all of them in law and policy. And then we're going to open the floor for your questions, and then we're going to take a break. So first, I would like to introduce Michael Veale, who is an assistant professor at the UCL, College of London. He's working on digital rights and regulation. His research focuses on how to understand and address challenges of power and justice that digital technologies and their users create and exacerbate. He has co-written a great piece on the AI Act proposals that I strongly encourage you to read. It's called Demystifying the AI Act. And I think the floor is yours, Michael.
See them. No, there's one of our other people has got them, but then hasn't synced in. We'll sort it out.
So while they do that,
wait, because there is a presentation right here.
So Michael has been teaching a class on internet policy. His syllabus is online. All his syllabus are online, and I think they're giving a good perspective on the issues we've been facing on how to regulate technologies, and here it is.
Great. Point it up a bit. Okay, hi everyone. I want to give a brief overview of just certain aspects and also some controversies and some questions, policy questions, in this very live piece of proposed legislation proposed by the European Commission last year, called the Artificial Intelligence Act. Everything used to be a regulation or a directive in Europe. It's now an act because it's sexier. And there's a lot to demystify. It's actually quite a complex proposal and piece of regulation. And it's one of many in Europe at the moment coming out in regulating digital issues. But it's got a lot of myths around it, and we can maybe hope to bust a few of those and start a debate with the practitioners who are here and people who come from different areas. So in this act, it understands AI systems as posing different risks. I won't get into how AI systems are defined, but it's really kind of broadly looking at consequential software that is involved in decision making. And there's discussions, and it's a very live question about exactly how to define it. But broadly, there are 3 different risk levels in this proposed act. I'm only going to focus on one of them. There are some risk levels that are unacceptable, that attract prohibitions in the act. There are also some risks that are limited and attract some transparency obligations on users. And both of these have lots we could talk about. But one of the main bulk for especially practitioners here in applied settings will be a system of high-risk AI. And these are a narrow range of application areas which the legislator and the commission believe may endanger fundamental rights and freedoms more than other applications. This is very similar to certain products on the market which are particularly dangerous. And they fall under a regulatory regime that is called the New Legislative Framework. And it's actually not very new at all. It's been around since the 70s and 80s. And it's a very common tool of the European Commission and the European legislator to regulate risky products, allowing them to move freely across the European Union while ensuring that they don't explode in people's faces or a lift doesn't plummet to the ground. And that's the regulatory approach that the European Commission takes here. So this approach that's taken for AI is this 40-year-old approach to regulating complex products that have engineering aspects often. And it uses a pre-marketing approval. So before you put a product on the market, you have to check it's in compliance with a certain array of standards. And so the idea of how this kind of law is made, and it applies to the AI Act as well, is the legislation itself, so that the text of the law defines certain essential requirements that this product or system has to meet. It can be very high level, it can be a bit more detailed. And then the European Commission says, well, we're going to turn to European standardization bodies, which are often kind of clubs of national standardization bodies or other industry actors. Sen and Senelec do a variety of products, and ETSI is a telecoms standards maker. Sen and Senelec look like they're being turned to in the AI Act, and they're groups of all these national standards bodies, like the German DIN, for example, will be a member of these bodies. And they look at these essential requirements and they flesh them out and say, we're going to, in the standardization process, we're going to work out exactly what they mean in different contexts. They publish these standards. The Commission looks at them and says, okay, that's a bit of a contentious process in itself at the moment, but we're not going to go into that too much. And companies then can follow these standards. And if they follow them, then they are in conformity and they can move their product freely around the union. Sometimes they have to be checked they're following them. They write some documentation up, and then a company looks over it, like the TÜV is a big company that does that, for example, in Germany. And they're called notified bodies. But they don't go and check the products. They don't put them in a lab and do tests on them. They just look at whether the process has been followed. And so then after that, you get this CE marking that goes on your product or service, and that allows it to move freely across the union. So in this case, we can look at the different products that already fall under this. Lifts, medical devices is the biggest one for many people in the room that falls under this, and indeed many people will remember the scandal around breast implants that were dissolving the PIP breast implants in people's bodies. That was a product that was regulated by this framework and created a lot of debates about where responsibility lay for that issue. And toys as well fall under this kind of regime. But you've got other things, high-pressure canisters and things like that. And you also require this for importing into the EU. So, for example, even if Switzerland didn't apply the AI Act, then Swiss organizations who wanted to sell these systems into the Union would still have to follow these rules. And Switzerland has a mutual recognition in conformity assessment agreement with the EU that means that some Swiss bodies can also accredit individuals or products to these standards as well. So that's the background of this approach. What does it apply to? Well, here's this huge, intimidating table, which is always the point in a slide deck where someone says, and I don't expect you to read this. I'm just putting it up here for words. Kind of I am, but it gives a feeling. So you can see there are these application areas, education, employment, some law enforcement areas, border control, things that judges use. And within these areas, you have more specific application areas. And these are kind of AI systems intended to be used as polygraphs, so lie detectors, or to assess people, the authentication of travel documents, or help judges, or admit people to universities, or mark their assessments. So there are these narrow areas, and many people in the room who work in machine learning will not be developing systems that fall under any of these areas. And if you do, you probably know it. You probably know that you're working in a bit more of a sensitive environment than another area. Also, anything that's an AI system embedded inside other kinds of products that are already regulated, like medical devices, is caught by the AI Act to some degree. So this is both a broad list, but also quite limited and narrow. You know, we're not talking all AI systems. We're not talking about systems on social media generally. We're talking about systems that are sold often to the public sector, not entirely, but often to the public sector, for things which really can impact upon people, their environments, their communities, or the safety of physical systems. And the essential requirements are quite broad, so providers have to ensure that they meet some discussions about data quality, there's some transparency sufficient to allow oversight in use, there's some logging and documentation, and so on, and also cybersecurity and accuracy issues. I said these are written quite broadly, maybe less broadly than some other pieces of legislation, but still they apply to a whole range of areas. And actually new for the union legislator, they start to put requirements on users of these systems. Not many, pretty much users have to do what they're told. So they have to not use a system off-label, like you might say for a pharmaceutical product. You must do what the provider tells you to, and most of the responsibility falls on the provider of these systems. Okay, so that's the overarching view of what the AI Act broadly does. I want to just highlight a few areas that we should be maybe paying more attention to in the debate as this piece of legislation passes through, and I'm sure we'll talk about them more. So firstly, these private standards bodies have a big role because they're translating these requirements from broad terms into something more specific. And once a standard exists, actually it can be just applied and there's an assumption the law is followed. The AI Act doesn't even require organizations to have their working checked by a third body, actually, in most cases. And so they have a big, important role in this. And the challenge with those bodies is that they're often made of technical experts and so on that are not very accountable. They're not always expert in fundamental rights or things like discrimination or transparency or the use of systems by judges. So this is they're more used to standardizing areas of technical standards than of social norms and rights. And they touch upon a lot of different rights, so that's a big challenge. There's limited social representation in these bodies, and that leads to a legitimacy gap. So we have to think about whether these bodies are really the right organizations to be taking the lead on making rules in this space, particularly as many of them have already started to make rules here, even before the law has been passed, without NGO or civil society oversight or input. And I also want to just draw attention as a high-level point to the way that the political economy of AI works today. We look a lot at big models being trained by some of the cloud and tech giants as general-purpose systems for vision, for text analysis, generation, even for analysis of things like video, which are going to be extremely compute expensive to do. And in these cases, these are high-level systems that SMEs and small companies just deploy in their work. They cost huge amounts of money and also a lot of carbon to train. And it's questionable because in the AI Act, a lot of responsibility is put upon the organization that decides to sell a system to judges or to schools or to hospitals or to the police. They have very little ability to negotiate with providers like Google or Amazon about the conditions under which they're trained. Many of you may have heard of the firing of Meg Mitchell and Timnit Gebru from Google for writing a paper that criticized the ethics and the oversight of large models like these. They pointed out in particular that some problems can only be solved in that very, very upstream process of building these giant models and not downstream. But the AI Act doesn't really give any responsibilities to these general purpose providers who sell a system that's then purposed later on. So there's discussions with asymmetries between the companies. And we have to ask then, what does the supply chain of AI look like? Who should be taking responsibility up and down this supply chain? And how do we empower organizations to use real and appropriate methods across that? And indeed, there's been some lobbying harder work already in the Council of the European Union, which is the group of member states acting sort of in an executive capacity, negotiating together between governments. They proposed to add a quite clear exemption on top of the exemption that already really existed in the AI Act, to say systems that are general purpose do not have the responsibilities that we give to more specific providers. And I think this is a worrying trend because we have to grapple with this political economy. Many people working in AI are turning into drag and drop API users. And that is very hard to be in a position of responsibility and oversight for. So to finish off, what I think in this area is we must be very careful not to delegate decisions about fundamental rights to private standards bodies. The devil is in the detail here, and these need to be very inclusive processes, and it's not the same as engineering standards. We can't pretend that just because technology is involved, that fundamental rights is not at stake. These are not the appropriate bodies to be making these decisions as a whole. So how do we provide accountability over processes that can be quite technical? We need to grapple with the whole AI supply chain, because some questions cannot be answered alone by SMEs, and need to be given power vis-a-vis AI as a service platforms. And something we'll talk about, I think, in the panel is the enforcement of this act, which is a difficult nut to crack. And we need to make sure that it can really bite and provide oversight, because not all technology regulation in this area so far has had successes in that area. So thanks a lot, and yeah, I'm looking forward to the rest of the panel.
Thank you, Michael.
Yeah, I'm ready. I'm done.
I think we can put the next, yeah.
Yeah, I saw that Paul's coming out.
So thank you for this broad and precise presentation of the AI Act proposal. I would now want to invite Belén, who is an attorney, a Spanish attorney, specializing in technology, including AI and machine learning. She has been advising clients in digital corporate data privacy, compliance, and so on for over 20 years. She was one of the first lawyers in Spain advising clients in that area. So we are really lucky to have her. And she is also now the president of the International Foundation of Computer Law Association. So Belén, I think the floor is yours.
Thank you, Suzanne. So thank you very much to the organization for having me, and especially Suzanne Vergnolle, who so diligently and kindly organized this panel discussion with the three speakers today. Thank you very much. Right, so I'm going to speak more broadly about AI systems and regulation. First of all, AI systems and how they will change the world. I'm not here the one to explain to you, but we have AI systems deployed in all kinds of sectors: health, insurances, transport, logistics, justice, defense, human resources, social media, etc. We are currently witnessing an increasing delegation of decision-making on AI systems and algorithms, including on critical infrastructures and applications, as well as in areas of potential impact to human rights and our welfare and values as a society. So this is why we need robust systems and ethics-based systems, as well as governance structures for AI systems. In this way, we will achieve that such systems are transparent, explicable, and therefore trustworthy. Currently, many systems are based on machine learning technologies as well as deep learning, but we have also black box systems, where the relationship between the parameter used by the algorithm and the result of its application are not known. A correlation, not a causation relation, is applied, for there is no cause relation between inputs and outputs, and the results are not explained, which also affects the training data sets, the decision of the architecture and design of the system, and the systems and optimization processes. So input data as well as decision made can lead to discrimination and human harm to other human rights and can affect safety of consumers. We need, therefore, framework on reliable AI, including ethics, regulatory, and governance frameworks. In the ethics sphere, with principles and requirements like non-maleficence, justice, explicability, and autonomy. In the regulatory sphere, with elements like soft law and codes of conduct. I think we are going to speak about that later. So codes of conduct, best practices, standardization, and certification mechanisms. In the governance and accountability areas, we need the participation of the stakeholders, education of developers, setting evaluation and auditing standards, and explaining risk assessment processes followed. Now, the requirements for trustworthiness in AI would then be human agency and oversight, technology, robustness and safety, privacy and data governance and regulation, transparency and explicability. For achieving AI trustworthy, we need technical and non-technical aspects. We need ethics, we need the rule of law by design, and we need accountability. Now, examples of frameworks. As you know, there are a myriad of policy frameworks around. I'm going to discuss one I contributed to produce, which is the Global Policy Framework on AI drafted by ITech Law. ITech Law is the global association promoting network and thought leadership amongst leading technology lawyers worldwide. And together with a team of 38 specialists from 17 countries, we produced the Responsible AI, a global policy framework, which sets a set of principles and then overarching principles, developing such principles, as well as a very practical tool for developers to assess their systems and products. It's called the Responsible AI Impact Assessment, RAIA. So the first principle we came up with was the ethical purpose and social benefit. And it goes like organizations that develop, make available, or use AI systems and any national law or industry standards that govern such use should require the purpose of such implementation to be identified and ensure that such purposes are consistent with the overall ethic purposes of beneficence and not maleficence, as well as the other principles of the policy framework of responsible AI. The second one, I'm not going to develop or explain each of those. The second is accountability. Then it's transparency and explainability. Fourth is fairness and non-discrimination. Fifth is safety and reliability. Six is open data and fair competition. 7 is privacy. And 8 is AI and intellectual property. As I stated, the principles are complemented with this assessment tool, the Responsible AI Assessment Tool, that sets the assessment instructions and steps. So developers must first fill in the essential elements or information about the AI system they are selling or preparing, and the project within the project summary section, then determine if a RAIA, so an impact assessment, is necessary by evaluating the key risk factors as per the key risk factors of RAIA, and then for each principle, answer each question as in much detail as possible, determining how the AI system will impact or address the risk factor. Then determine a risk rating for each risk factor of every principle, and based on the risk rating, determine tailored mitigation measures to reduce the initial risk rating. Consider then the impact of the mitigation measures on the risk factor and revise the initial risk rating, and then review periodically. So this is one example of one framework you can use for your products. There are a lot of initiatives and policies all around. I'm not going to discuss the proposal in detail because my colleagues of the panel have done so, but a few of them I can tell you about. At EU level, we have the Digital Agenda for Europe, the AI Strategy for Europe, AI Coordinated Plan 2019-27, How to Measure Digital Transformation by the OECD, the White Book on AI, which aimed at reinforcing industrial and technical capacities with the corresponding regulatory adaptation, the impulse of its growth in an ethical and trustworthy manner within a framework of security and liability. Then the European Policy on AI, which set the framework with technical and security aspects, with protection aspects, inclusive, legally, and socio-economical, to put AI at the service of citizens. A policy that is citizen-centered and with trust in AI that sets the basis for a coordinated plan for the member states. Then the DSA, the Digital Services Act, and the DMA, Digital Markets Act. If I'm allowed, I will use 2 minutes more. Of course, the EU a regulation proposal, and a series of developments within the Council of Europe I wanted to tell you about. There is the work of the Council of Europe, which can be found at COE AI. Then there is the ad hoc committee on AI of Council of Europe called the CAHAI. The CAHAI has done a feasibility study for a regulation on AI, which determined that there's no legal vacuum actually, but important gaps within the legislation. And so an appropriate framework should be established by means of first soft law, then a binding instrument regarding human dignity and human freedom with key obligations and key substantial rights. If I may, I will discuss about a national initiative in Spain, the ENIA, and I'll leave the rest of comments I had for the discussion. Is it okay? Let me just explain in 30 seconds. The Spanish ENIA, this is the strategy on AI developed by the Spanish government. In Spain, just 10% of SMEs has adopted AI systems. Just 18 of big companies has adopted AI systems, and there's a study that estimates that companies lose from 10 to 20% income if they don't have data apps on AI. So they have developed this national strategy, Estrategia Nacional de IA, ENIA, with the goal to align the Spanish policy with the EU policy. The goals of ENIA are to gain scientific excellence and innovation in AI, the protection of the Spanish language with the development of tools, technologies, and applications for the use of the Spanish language in fields of application of AI, then the creation of qualified employment, the transformation of the productive sector, the creation of a trustworthy environment for AI, and the development of human values in AI, included the production of a digital rights charter, to whose drafting I had the honor to participate. And the action plan includes 6 strategic axes, including the promotion of the development of digital capacities, the development of a platform of data and AI support technical infrastructure, the integration of AI in value chains for the transformation of industry as a tool for productivity and efficiency, to link it to sustainability with the so-called green algorithms program, and to boost the use within public administration as well. It sets up an ethic and regulatory framework for strengthening individual and collective rights. The goal, they say, is to gain back digital sovereignty for Europe, and it is apparent that the EU is too much dependent on the big tech players, and the development of the digital sovereignty implies to develop an own European software, own cloud capacities, and own computational capacities. So that will be it from me. Thank you.
Thank you, Belén. Yeah, that's also another level of difficulties, how and at what level you need to regulate technologies. Should member states have their own laws and then the EU comes in, or which is what France has done with one of their proposals, the Digital Services Act. They took some of the provisions and put it in the French law before the European regulation was adopted. And it's interesting to see member states starting to take action before the EU sets the movements. So now our third speaker I wanted to introduce you is Paul Nemitz. He's the principal advisor in the Directorate General for Justice and Consumers in the European Union Commission. So he's been working a lot on these issues for the past few months and years. Actually, he has been working at the EU Commission for over 30 years, and he had led the reform on the General Data Protection Regulation, and he was one of the key negotiators of the Privacy Shields, which is for the audience who is not familiar with these terms, the legal instrument allowing the transfer between the EU and the US for personal data. And he has been, he's been quite active in the technological and law policy developments for, I would say, a decade. So we're also very lucky to have him. And Paul, the floor is yours.
Thank you, Suzanne, and thank you to the previous speakers. Also, this my slides look more or less like those of Michael, so I don't need to use them. But I would like to follow on to the excellent presentation of Michael to say that, of course, in a political process, in a democracy, you have pressures from all sides. And a contribution like the one of Michael is vital. I remember when we negotiated the General Data Protection Regulation. At the time, I was the lead director in the Commission, and we were thankful for any type of counter arguments, which help to counter the lobbying of big industry at the time, singing from one hymn sheet with the American government and all the trade associations to which they are member, and there are many of those. So this is also the process which we are now going through in relation to AI. The fact that there are amazingly one-sided proposals by the lobbyists on the table should not surprise anybody. What is more noteworthy is first of all, that we are coming out of a culture of John Perry Barlow. The internet doesn't need any laws. The Declaration of Independence of Cyberspace in the 90s, we know now that this has done a lot of harm, but it has taken years to get Brussels around to recognizing this. In Washington, one has the impression they're still singing the song of John Perry Barlow. At least they are not getting the act around in making laws which regulate the internet on a nationwide level. So I think that is the first thing, if we look at this from the point of view of democracy and fundamental rights and the rule of law, that we have to recognize that the process of regulating the internet and technology is a process where you have a lot of people who still think the most important rule of the game is the unbroken global internet. And the doctrine of the unbroken internet has as a consequence that you cannot make regional rules in democracy. It's the end of democracy if you put that rule as the highest rule. It took some years to get people around to this. And to make this more concrete, in Brussels, the discussions on AI, the early ones, started along many concepts which Belén mentioned, self-regulations, ethics, and so on. And you know, the reality is the politics in Brussels is a multi-party politics. It's always what we call a grand coalition between social democrats, conservatives, liberals, Greens. You need many parties on board. And the Commission, of course, is also a reflection of the political reality of Europe, where, you know, I would say there are leftovers of the neoliberals. There are leftovers in a retreat battle, you know, not winning a lot of elections right now, but they are still there, and they are still very powerful. And you know, one of the key players, for example, on AI in the European Parliament, Axel Voss from the EPP, you know, is very well known also from the general data protection regulations, and everybody knows where he stands. So one doesn't need to be surprised that the proposal of the Commission is a proposal which appeals both to industrial policy people who don't think, you know, anything of the law at all. You know, it's just a cost factor, and it's just annoying, and you know, actually we don't need it. It's a growth impediment. We don't want it. And it appeals also to those who stand for fundamental rights. And what is now happening is that this negotiation in the Council and in the Parliament gets fed with a lot of ideas. And I can say it is vital, if you are interested in the subject, to make yourself heard, because Brussels politics is really very responsive. In the case of GDPR, we had 4,000 amendments in the Parliament to work through, and many of these amendments were written either by the corporate lobbyists or by the lobbyists of academia or the lobbyists from civil society. And by the way, I wouldn't call the academia lobbyists. You know, I mean, there is the lobbyists who do it for the money and for the profit, and there is civil society, which is, I would say, a different thing, and academia also. So this is the process we're in. And let me say that I think it would be wrong to assume that everything is going wrong and everything is lost, and it will end up in the hands of the big companies through this model of giving a mandate to norming organizations. I think all the risks Michael has described are real. And I would say in this new world in which AI as a technology will be omnipresent, and omnipresent not only like machines which can do physical harm, but omnipresent in relation to decisions which concern our fundamental rights, which concern the good functioning of democracy, I think it is a good moment to have a closer look at how these norming organizations function. And I think that is what the Commission will certainly be doing, and I hope very much that others will be doing it. But the reality is there is nobody in terms of existing institutions which now has the capability of from one day to the other implement and apply and enforce an AI Act. You know, what would be the better alternative among the existing organizations to going the road of a methodology which we already know and which necessarily, and I think everybody recognizes this, necessarily must evolve in light of the new challenges, which are that we're not only talking anymore about safety and security issues, we are now talking about a technology which goes to the minds of individuals and which goes to controlling behavior of people and of societies and taking key decisions and thus has an impact which is much more value loaded than the classic products and machineries which were regulated through this type of process before. Does this mean that this process is useless and we should have come up with something different? I can tell you, there was a lot of discussion in the Commission, and it's very difficult. We are starting a new age with a whole batch of legislation. Most of this legislation is cutting edge, and I would say we are now in a finding process. We are in a finding process where I would hope, like on GDPR, that what comes out of the legislative process is actually more informed and better than what went in. So let me say that I think in terms of the purposes of the regulation, the most noteworthy thing is that there was a proposal for a law, because for this area, that's a big step. Remember, the chairman of the high-level group on ethics, which the Commission had put in place, was going around and said, we don't need a law, we don't need a law. Former head of Nokia. And the German government, called a data ethics commission. Everybody was jumping on this train of data ethics worldwide, more than 80 ethics catalogs. Probably a lot of lobby money already went into setting up this concept that now we don't regulate technology anymore by law, but we're starting a huge ethics debate, allowing the companies to say, well, guys, we have done it all already. You don't need to make a law. So, I think nobody is naive about this, but I would say in this game of power and about the question who rules, is it democracy which rules, is it the technology, is it the companies with their technology? Hans Jonas said, capitalism plus technological development, brush everything else aside. In this game, I would say it's a huge step forward that we are now talking about a law which goes through democratic process. And I would like to ask your understanding that in this time of war against a democracy, a free country, and in this time where also before the war, we were already talking about the crisis of democracy, it is good that we use the most noble instrument of democracy, which is the law, to deal with this omnipresent new technology. So I see this as a progress. I think we have to end talking down the law, as a costly obstacle to innovation. But we have to recognize that we need to address these issues through democratic process for a number of reasons. Because first, we need the democratic legitimacy. Let's be clear about it. I've been myself following the high-level group of the EU. I was member of the German Data Ethics Commission. The idea that politics can be replaced by an ethics committee of wise men and women is engineering thinking transposed to societal thinking. And it doesn't work. The idea that the wise people just have to get together and then we don't need politics anymore is just wrong. My experience is all these ethics committees inside, when they were really important, it was all politically negotiated. Very clear. So it is a step forward that we recognize we come back to democratic process. Second, we need the legitimacy of the law because we are dealing with powers which don't play ball when we make laws. They don't want to comply. They seek every way to cop out. And therefore, we need the power of the state to enforce, including against powerful companies like the ones you mentioned, the GAFAM and so on. They have to learn that they have to comply with our law, and it only works with law. It doesn't work with ethics. So we need the law for that reason. But we also need it for a third reason, which is that we want to protect Europeans in all member states in a similar way. So we need to have a level playing field for citizens, and we also need a level playing field for companies. And you see, you don't get a level playing field if you leave everything to ethics catalogs or self-regulation. Because if you leave the choice to companies to sign up or not, you always have the problems that the good-willing ones, and there are some who would be ready to sign up and they would be ready to play ball. They always say, but if we sign up and these other guys, they don't sign up, they will undercut us, there will always be rogue players. And then everybody is drawn down. Then the good intentions start to crumble, because after all, we all operate in capitalism. We're all, going for the same type of capital input, and it becomes dysfunctional, and the internal market doesn't work. So that is the third reason for a level playing field in the European internal market. We need rules which are binding and for everyone. And let me end with the following thought. I think it is right and good, and we need a critical debate, and I think we need the critical debate right now to counterbalance, the activities of, let's call them, the business lobbyists. That is the balance in the political game which we need, and the Commission is usually, very, very open and very, very thankful, and also the members of Parliament are. But I would also say, let's not put ourselves into a position, and this is a classic lobby talk in Brussels, which is that we either want a good law or no law. The engineering thinking of perfection, the code must be perfect to function well, transposed to democracy, is just leading to results which are not acceptable in democracy. The reality is every law is a negotiated compromise between many to get the majority. We will not be able to either satisfy science nor the company lobbyists. I mean, the cynical Brussels bureaucrat me type of sentence is, if all are screaming at the end, this is shit, probably we're quite right. If one side is only screaming, we've probably got it wrong. As a rule of thumb. So the reality is, in democracy, the laws are negotiated, and I think that's not a bad thing. And I would also say that the great advantage of now doing a first batch rather early on, if you think about the time which was necessary to regulate the internet compared to the time in which we're regulating AI, I think this reflects another evolvement in thinking, and this will be my last remark. Not only was there an involvement in thinking from, John Perry Barlow, then ethics catalogs, to using the law, there's also an evolving thinking about the law following problems which come up in real world, and the law anticipating the future. The neoliberal thinking is, let's wait, let's have the little flower bloom, and we make the law much later. We don't know yet what we're regulating, and so on and so on. We live in a world with so fast-moving technologies, and this is not only AI, this is also in biotech and so on, that we have to change tech from, let's say, the ex post regulation, which is also often very sectoral and relates to the specific problem which has been observed, to a regulation which anticipates potential problems, a precautionary regulation, a regulation which uses our technical fantasy to imagine what a technology could lead to, and once we have imagined that, makes laws which hopefully avoid this. And this is a difficult exercise, and it is an exercise for which it is even more difficult to get majorities. And I think with AI regulation, we are a little bit in this field already. And so a fortiori, I would ask for, let's say, your understanding and your support that we are on the cutting edge here. I think there will be majorities to make laws. They will not solve all problems of this world, but on your specific point, Michael, I think reading this regulation, I will formulate it differently. I'm sure there are some people in corporate lobbying who have the strategy to make this regulation as empty as possible and delegate everything to the norming bodies, and then they try to capture the norming bodies. That's not what the Commission wants to reach here. And I think what we are in the business of making laws which, as such, as democratic products, make a difference in the world. And that's also the job of the European Parliament. And I would think there's a majority of members of the European Parliament who take this job serious. But, that being said, it is good to point people to the types of risks which you have identified, and to make sure now in the legislative process that we don't get wording which allows to realize this potential of, basically making a law which is just gesture politics and doesn't have an impact in the real world. I think that's the challenge before us, and please support us in making it happen the right way. Thank you very much.
Thank you, Paul, for this inside the room discussion and great presentation. And I cannot imagine how much work it must be finding the right wording and finding the right balance between different interests and so on. So thank you very much for that. I would like to take a step back because we've been talking a lot about the way Europe is regulating AI, and there are many other countries right now looking at regulating this technology. For instance, Canada has put forward the Ontario's Trustworthy AI Framework proposal. China has adopted a lot of laws recently regulating the data processing and also recommendation algorithms. The EU has this AI proposal and so on. And Michael, I think it would be great if you could tell us more about these proposals, but more specifically, if you can tell us what are if the countries are going in the same direction and the principles that are getting from this framework.
Yeah, thanks, Suzanne. There is a lot of interest. I think that the EU is the first jurisdiction really to start to regulate AI as a whole idea conceptually in the law, but there's plenty of regulation that talks about regulating machine learning in different ways. Firstly, we can notice that about 150 countries around the world have some form of data privacy law, and many of those countries have provisions around profiling and automated decision-making that draw themselves also from particularly the 1995 Data Protection Directive and the Council of Europe Convention 108, some more recent ones from the GDPR, and they have provisions around this. So that's a backdrop, but and that's a kind of good start and a baseline in some ways. You see countries, I think, first off to move to procurement requirements. So when there are public sector initiatives to require systems that are bought by the public sector in tax or welfare or so on, then there can be standards for procurement of these systems. That's often quite easy to do. It doesn't require statutory law. And you also find a lot of law around regulating social media, internet activity, content, recommender systems, sometimes economic exchanges online, like market competition between companies. And those regulations, particularly around recommender systems and so on, are another method of regulating AI. I think what's interesting, just to finish off there, that the EU is the only place I know so far that tries to regulate AI as a product. And this does come in a way from the genesis of the European Union, and Paul mentioned the internal market several times and the importance of that. And the type of law that the AI Act is a law that is explicitly designed from the first recital to deal with the fragmentation of laws across the EU. And that's interesting in itself because it both has a process of deregulation, like there are some things that are in the current draft would be member states would be not allowed to regulate after the AI Act comes in. There are some, if a country or a member state decided to regulate a non-high-risk AI system or the use of it, there is a good argument that regulation would be overturned or prohibited or disapplied by the AI Act. And so there is an element of free flow of systems, as well as this re-regulation for the high-risk systems in particular. So that regulation as a good or a service is new. And we may well see more countries follow that going forward.
Yeah, thank you. We've seen the EU's influence on the general data protection with a lot of countries around the globe adopting similar legislation. So probably we can say the EU is actually the leading regulator right now in the digital space. And on that point, there's a website, the train schedule from the EU Parliament, where you can follow the different legislative proposals. And on On digital, you have around 80 proposals right now. So there's a lot of rules coming our way and coming the industry way. And so I would like Belén to tell us more about how the industry is reacting to these various proposals and the new legislation coming, because it's a lot of, I would say, pressure for them to, at least if they want to be to do legal to do legal processing and everything. There's a lot of things coming up. So can you tell us a bit more about that?
Sure. Thanks, Suzanne, for the question. Of course, if they want to be legal, as you said, and to comply, then they go to attorneys like ourselves. As you said, I've been advising tech companies for over 20 years now, and more and more they come to you to understand at an early stage the laws which are coming and affecting and impacting their businesses. I can tell you there's a huge expectation, not only because of the Services or Market Act, but specifically because of the AI proposal. For instance, I have clients who are in the facial recognition business, proposing products and services at the moment not within the EU but abroad. They would like also to sell within the EU. And so their general claim is that they need legal certainty as soon as possible. So long adapting periods and schedules are not helping them in advancing their technologies. They prefer to go somewhere else. They prefer, well, they are sometimes forced to go to the Middle East, Asia, etc. This is my very recent experience with these clients, not only clients in the facial recognition business, but also other kind of clients who are willing to adopt this kind of tools in order to automate their processors are hesitating whether to buy this or this other solution. So the message for me would be they need legal certainty as soon as possible and legal framework as well as self-regulation that they all know.
So you would say the sooner the law is adopted, the better it is. So it's better, for instance, with the general data protection, it took 4 years of negotiations, and it was a very long process. And recently, for the past few acts, the Digital Markets Act, which was just voted last week, was adopted in 15 months. So you would say that is better so they can plan which technology and which direction they want to go.
Not just that, I mean, they have to understand what will be mandatory. They want to comply, and so they need to understand what are their rules. And yes, we are seeing, as Paul explained to us, that the adoption periods are shorter and shorter. That's very good news. But of course, you know, the pace of innovation, etc., they still want it, you know, quicker and faster.
Thank you. I think, Paul, I might have a question for you on the way, because you kind of made it pretty clear that you need more insights during the legislative process, calling for experts, maybe technological experts in the room, to clarify some elements, show loopholes and everything. And I was wondering, how might the private sector work alongside the public sector to define incentives for safer AI? And do you believe such incentives could exist?
Well, I would say, first of all, it has a great marketing advantage to come from a jurisdiction where the laws are strict, which protect consumers, which protect fundamental rights, which protect individuals. Why? You can tell your clients or your customers look, it's not only our small startup which is making you this promise. If I don't comply with all these strict rules, I get in trouble with the regulator. So you can be sure I comply. And, you know, when we look at GDPR, I remember, you know, it took me 6 years of my life to get this legal act through. You know, huge fight against it from some big corporations and so on. Once the law is in place, some of these corporations, they turn around and say, we now guarantee our customers worldwide GDPR standards. And the budget from the data protection officer, which we didn't want to have in the beginning, you know, fought against it. Now it's paid from the marketing budget. Why? Well, because they realize that it's an extra good argument, in addition to many other arguments, you know, user friendliness and so on. I don't want to say that privacy is the first argument, but it helps. It helps selling. And I think this is the philosophy. You know, the European Commission is an economic body. Our job is growth and wealth of Europe. It's also now democracy. We are young in the game of democracy and fundamental rights. I mean, you know, Europe started as the European Economic Community, then it became the European Economic Union, then it became the European Union, and the word economic disappeared, but it's still very strong there. And so you always, rightly identified by Michael, you have these two objectives, at least two objectives. On the one hand, you know, we want to do something which is good for our economy, which is good for our companies. On the other hand, we now have to secure fundamental rights and good functioning of democracy and rule of law. How in this context now private and publics work together? Well, I would say this. The question of how to do products which create efficiencies and at the same time don't screw people, but respect their rights and even strengthen their rights and make it possible for them to manage their rights and insist on their rights and make democracy function better. You know, these are great challenges of our time. And I can only say, you know, this will be a market also. You know, people like, let's say, for example, search and recommender systems which are not just commercialized and you know, towards more buying and more advertisement. There are people who are ready to pay increasingly, let's say, for curation systems of news, which are really providing a quality input. Yeah. And you know, the New York Times, as a quality product of news, gets millions of people who are ready to pay on the internet. And so I would say privacy has also become a market. There are companies who now make money by providing the systems to comply with GDPR and also empowering individuals. And I would hope the same applies with to the AI Act. In the end, if the politics of a country or of a region are right, you know, the engineers will be asked different things from the state then they will be asked in a Trump administration. So, you know, let's not forget the state is often, in many countries of the world, the state is the biggest buyer. The biggest buyer in the world is the United States government. So if you ask me, you know, cooperation between private and publics, it depends a lot on political orientation, and, you know, some innovators are smarter in this than others.
Thank you. Deep diving into the AI Act and the way the proposal is regulating AI with this risk-based approach, going from prohibition for manipulative and social scoring and so on, and high risk with a lot of criterias and transparency requirements and so on. So what are your three views about this risk-based approach? Is it the right way to actually regulate AI? There were other ways, and that was the one chosen by the EU Commission. Is it the right way to actually tackle the legal problems coming from AI, or is there another way? So maybe Michael.
So I think, you know, I'm always really torn when talking about the AI Act? Because on one hand, I think I do agree with Paul that we're not striving for a perfect law here. On the other hand, it is really difficult for me to imagine the AI Act being the right direction, given its very, very product-based foundations. So the AI Act comes in, assumes that the AI is a product in a supply chain that you can regulate as if it's moving around. That should be the primary frame which the legislator should see AI through. And that comes from the fact that's what the European Union does a lot of the time. It's free movement of goods and services, and that's part of its core mission and what it strives to do in the treaties. A really big challenge, though, is that AI is not just a product. AI actually reconfigures power relations and reconfigures organizations around the place. It reconfigures who makes rules. Do schools decide on exams? Does some other country decide on exam criteria? Some other company decide on exam criteria? Are risks that people take every day externalized because they have to deal with many, many automated systems in their life and they actually have to deal with reconciling that? What's the role of different businesses and different organizations in those processes? So AI is also more of a way of organizing things. It allows us to have different methods of distributing costs around society, risks and decisions and accountability and legitimacy. We see some of that in acts that try to tackle power, like the Digital Markets Act, but they don't really deal head-on with, I think, this reconfiguring nature of AI. So this whole risk-based approach where you look at sort of different products and you sort of say, well, either their creation or their use can be classified in different risks, sort of treats it as if it's this box. If anyone's seen the IT Crowd, it's a comedy and there's a point where someone who doesn't really know about IT but is head of an IT part of a company says, she gets fooled into thinking the internet is in a box and can't drop it, otherwise it will destroy the internet, and she presents it in front of everyone. But of course the presentation goes great because all the audience don't know any different as well, so they're all clapping and this is a very similar kind of thing. And that's my kind of view, is that we could get into, I alluded a bit towards the challenge of harmonization and who can then make laws after the AI Act passes, and I think those are important. But broadly, the challenge that I just want to finish off then is say that all this new raft of EU legislation around digital technologies is actually based on a part of the treaty that's designed, the treaties of the European Union, that's designed to, if the Commission sees there's differences in member state law, it can say, well, that's a big threat to free movement of goods and services or people or so on, and we can make a law that smooths it over, and to a high standard, but smooths it over. But that's, that logic is maybe not the best way to deal with some of our digital issues. I would much rather, like we had in the EU treaties, parts of the treaty that say we actually need to deal with digital power and deal with some of the challenges that information technologies provide of fundamental rights, like we do for labor or health or something like that. But that doesn't really exist in the EU treaty, so we fall back on treating it like a free market problem or free movement of goods problem. And that's one thing that I think is tricky to deal with.
So maybe we might need a new charter for digital rights.
Reform, okay. That's going to be another mess. So it's a rock and a hard place. It's a hard thing to fix.
Yeah.
Okay.
I agree. Well, myself, I cannot think about a different approach than the risk-based approach, because because we already had it from GDPR and we are familiar with it, etc. And so, in my view, also it needs to give more room or more flexibility for producers, as with the GDPR data controllers, to interpret the AI proposal and to act. So we need more flexibility and give the protagonism, I think, to the producers, to developers here. That said, I missed a lot a human rights impact assessment within the AI regulation. It is partially touched upon, but not myself, many other experts do miss the human rights impact assessment as a part that would be needed also within some paragraphs within the regulation, and not leaving just the matter to the policy frameworks like the ones I explained before. We need something more tangible, in my view, within the law.
Thank you.
I'm sure you
Paul?
want to add your views on that.
No, but I mean, that was a very, on the one hand you say more flexible, on the other hand you say more tangible on fundamental rights. I mean, this law is a compromise, this proposal is a compromise, and you can see it in many places. I give you one example. One of the big calls for lobbyists, of the business lobby was, we want sectoral rules. Only sectoral rules can work. Other people, like me, I mean, I'm of the deep conviction, we have to search for the horizontal rules, because sectoral rules, it certainly becomes much too complicated for citizens and even for business. We have now omni-purpose technology, AI, we have platforms which are multi-sectoral, and then we want to regulate only by sector. That means we under-regulate by definition. So I would say, we live in a world of multi-sector platforms, multi-sector technology, so we need also horizontal rules. And in this, in many aspects, this already in the Commission, this was a compromise. You can see it, let's say, in the definition of AI. The definition of AI has some general parts of definition, and then there comes for the engineers some of the buzzwords, in the annex, which type now, using technical terms. You can see it in the risk description, some general words of risk, and then an enumerated list of the risky sectors. So, I mean, of course, it's from an academic point of view, one can criticize a lot, but this is not about writing the best book on AI. This is about a law which you need majorities at the end, and which means you have to engineer your way through the majorities and see, where you get them. It's a different job, and I would also agree with Michael, that in an ideal world, like we have successively added chapters to the treaty, for example, on environment and precaution and so on, of course one can write, as a professor of law, I think it's good, and people should write about it and say, in the future treaty change there should maybe be a chapter on not only AI, but digital whatever. Does it mean that we don't have such a chapter, that we can't deal with the challenges of the digital? No, I don't think so. I would think, the basic issues of fundamental rights, the basic issues of market power, and so on, of course they have to be further developed, but our concepts are good enough to address all this, and I think we're demonstrating it now. I would think the whole batch of laws, and they're not 80, I would rather say they're 8, which are focused on the digital. I think they show that we get our act together. In contrast, if I may recall this, to Washington, where in Congress nothing is happening, nothing is getting through, and in a very different way than in China. In China, everything goes faster, including social scoring. So, I mean, if you want to have it fast, you can get it from the Communist Party, because it's a dictatorship. So, if someone wants it at the top, they deliver, but very fast. Only that, maybe the direction is not what you like. So I think we are doing something here which, it serves democracy. It's the first round. Probably in the future there will be more rounds, because the power struggle between the technological, economical complex on the one hand, dictators on the other, and democracy, they don't go away. It will not go away. So, in this power struggle, there will be probably a second and a third round. And for the time being, the task is to do this act as effective as possible, both for protecting fundamental rights, good functioning of democracy, rule of law, and for making the internal market work, which means, of course, we must provide our industry the basis to be top innovative, top competitive in this very important field of new technology.
Thank you. Yeah, and when you look at history, the way regulators and legislators around the globe started in the 60s, 70s, 80s, regulating data protection, there was this big question in, should we have an omnibus approach or should we have a sectoral approach? The EU adopted the 1995 directive as an omnibus approach, and the US adopted many laws, so sectoral approach, and so now you have in the US a law regulating renting of video when you go, to the little shop and get your DVD, and there are privacy protections for that, so you should be happy. But these privacy protections do not apply to Netflix, and on the long run, you actually see that sectoral approaches do age less well than omnibus approaches. So I think I would like to open the floor for questions from the audience. I have many more questions to ask our guests, but maybe some of you have questions. Yeah.
So as a disclaimer, I'm an economist, so I don't know that much about the law, but so another way to think of AI is not as a good, but as an infrastructure, right? So I mean, it's like the railroads. And so I'm taking away here that this hasn't been the approach that was followed, but to what extent was this part of the discussion? You mentioned natural monopoly, right, concentration, network activities, and so forth. So I'm just wondering to what extent you've been discussing that in the way of getting where we are now, vis-a-vis treating it as a good. Do you want to connect the question? Do you want to, I don't know.
No, but I can, we had years of discussion on this, and the competition aspects of the digital is, let's say, dealt more in the DMA. And let's say the reason why this methodology was used is because the lead DG is a DG which is together with the industry DG under the same commissioner, and they just know this, and they know that industry likes it, and that was the argument. And as I said, there's some people who are extremely relaxed and even happy about what Michael described, what happens afterwards in the norming areas. There are others in the commission who really don't like it, but it is, let's say, the prevalence of what is already there. Let's just extend it. It could have been in a different way, but conceptually it would have been more difficult, because then it would be even more innovative, and risk-taking in legislation is, that's not our job. We're not entrepreneurs. We have to get the majority, we have to convince people, this is fine, yeah, vote. And I would agree that probably from the political expediency, it's more likely that you convince people to vote for something which is more or less what they have already seen before, rather than coming with maybe the right genius new concept, but takes a long time to convince people to all then go along. So I'm sorry to say it's banal, but politics is about normal people. It's not only professors, unfortunately.
Hello, I have a question, I think, for everybody. How do you expect the states to behave regarding this AI Act? I think also for narrative of states like in France, Macron saying France should be a startup nation, in which in this narrative, like the AI and innovation and positivism really has a big part in the state discourse. So how do you expect states to react to what is in the end an attack against their narrative, at least the liberal narrative?
Thanks. Yeah, I can talk a bit about that. So I think one of the things we haven't really talked about very much is the enforcement of this act, and I think that is where it's going to run into some significant challenges, because, as Paul said, it uses a very old methodology. A methodology people are comfortable with. It extends it actually in very weird and unprecedented ways, which I think have some tricky legal effects. But one of the consequences of this is it relies on this mysterious actor at state level called the Market Surveillance Authority. And these are often, say, parts of government departments or so on. And typically they just had the role of, say, checking if toys are safe and organizing in collaboration with other European partners and sort of European platforms. the withdrawal of these from the market, or flagging of, this Barbie explodes if you pull her hair, and then on a platform that used to be called Rapex, which is not a great name for a platform. It's changed now, luckily. That's all fine. The problem is that these systems didn't really cover direct impacts on individuals or fundamental rights that relate to them, and they're configured very differently state by state. They're also not independent from the government in almost any state whatsoever, because product safety doesn't need to be very independent from the government, because the government's not a big manufacturer. However, we're moving into systems here of public-private partnerships. So the biggest challenge for states, I think, from the AI Act is not really that it's disrupting startups. These are very niche application areas. Only some companies sell this. It's that governments use these systems, say for migration and border control, or police, or universities, or enforcement. And so enforcement of this act is also about governments misusing these technologies, choosing ones that are incorrect or have not been certified properly or thoroughly, or don't meet those requirements, or using them in ways that go beyond expectations, like using them without proper oversight. And in those situations, you are faced with a national body that is the only body that can enforce this law. Citizens aren't conferred rights under this law, so they can't go to court and take say this high-risk product exists. I don't want it to exist. They can't say that. And in this case, you've got a part of a government department that's meant to be, say, going off against the Ministry of the Interior using a border control AI system, and is meant to stand up to it and say, whoa, we're going to fine you or stop you doing this. To me, that seems very improbable that will actually occur. So states are going to be configured in ways which I think don't regulate this in a way that is harming government use of these technologies. And when you looked at the high-risk technologies, they are largely used by governments. Now, there are some law enforcement, data protection authorities have some role there, but in other areas, no. So that's where I think the main reconfiguration of states, as well as the Commission indicates, this will require no more, I think, than 5 to 25 new people employed per member state, and that seems very, very low to me to enforce this act. So it's sold as something that's cheap for member states to do, but I'm not sure regulating AI is or should be cheap for member states to do.
Well, I basically agree with what was said. I anticipate there will be very differing enforcement amongst countries, like we saw or we are seeing with GDPR, that the different authorities are sanctioning in very different ways, and in terms of the amount of the sanctions as well. We are seeing this in my country, Spain, every day, with huge amount of sanctions for some concrete sectors, and other minor sanctions for other infringements, which are also important. And then the differences of criteria from this data protection authority to the others. So AI enforcement, I anticipate it's going to be diverse across the union as well. And because also a lot of GDPR component and privacy will be there. I don't know how we can tackle with this difficulty.
Yeah, I mean, in a country with, or in a region with 400 million people, even if you look closer at tax enforcement, and any enforcement of law is very different. I mean, that's the nature of the beast. On GDPR, I think, it will tend towards more harmony, because, they are policing each other in a discourse, and this discourse is slow, and they all have their habits, but I think they are learning to come to closer together, and certainly enforcement will increase. If you look at the numbers and the salaries of data protection lawyers, which go up, which for me is a proxy for what's happening in the market, I think it's taken serious now. And on AI, I would on the AI regulation, I would agree with the analysis of Michael. This, it is, it's all new, and we have to learn, and it's not all only about fundamental rights. There are other positions. By the way, my view, at least on German law, I don't know what the situation is in other countries. is that any use of AI in the public sector for decision making needs a legal base, because we have very clear laws which say automation in the public sector needs a legal base. That's in the general administrative law, and then it has been implemented in tax and in social aid. And if there's no legal base, automation already, and this is pre-AI, automation is not allowed. It must be decided by the civil servant. That's why we have a civil servant. I mean, there's a constitutional position of the civil service. So in the pre-AI age, you needed a legal base for automation, mechanical automation, input, output, always the same. I would say these legal bases are not enough for AI, because AI takes much more out of the hand of the human official, the possibility to decide. For example, the rules on automation, they say you cannot automate where there is discretion exercised. Very interesting. So a fortiori, you need a legal base anytime AI is used in the public sector. And there are other general rules which constrain the use of AI. For example, I think it's inconceivable to have AI which is not either giving reasons for its decisions automatically as part of the AI result, or where at least a human being can explain exactly the reasons why this machine has decided like this. Why is this necessary? Because we live under the state of rule of law, which means that every decision of the state which infringes on individual rights must be controllable by a judge. But a judge cannot control something when no reasons are given. So motivation is key. That's why, it doesn't matter what the AI regulation says. If there is an AI which is not explaining itself and not giving reasons, it cannot be used in the public sector where public authority is exercised. It may be possible to use it in the kitchen of the ministry, to do the cooking automatically. But when it is about exercising public power towards individuals, forget it. Cannot be used. And I think these are things we also have to talk about more.
I think we have maybe time for one more question. You already have the mic.
Thank you very much. What is Switzerland doing in the process of getting to that AI Act as a non-member state? And what should Switzerland be doing? What we do normally, wait as long as possible, and then wait some more, and then do a Swiss caricature of the law, or something else.
So,
Yeah, only from recently. I mean, when you look at the history of new legislative framework laws, Switzerland periodically imports them into its law. I mean, of course, I'm sure you probably know much better than I. It's a very confusing relationship between the EU and Switzerland, and it's very treaty-based, and it's very time-consuming and tiring for everyone involved. But that's how it broadly works. There's like a tranche, and then there's a decision from the Commission, an agreement between Switzerland. So it may be the case that the AI Act gets incorporated there. It's definitely likely that parts of it will be incorporated, because Switzerland imports parts of the rules on, say, medical devices and other risky systems. And the AI Act says, well, if you put AI in these systems, then it has to adhere to these principles of the AI Act as well. And so it's likely there'll be an update that will have to grapple with whether we choose to put in the AI Act for standalone AI systems domestically within Switzerland. Maybe, maybe not. Whether Switzerland, not Switzerland, but whether Switzerland puts it in, for example, so medical devices used in Switzerland have to adhere to the AI Act principles, probably, because that's an important free movement of goods issue. And so I would expect that in a few years it will be the case. And Switzerland does sit in these standards bodies as well, although it wouldn't necessarily have a vote on the mandated standards. It will have influence in them as well.
Also, Switzerland is often a passager clandestin of European Union because, for instance, for a lot of big corporations on GDPR, they just don't distinguish and just apply GDPR even for Swiss citizens. So they benefit from rights that the EU enacted without, having their own policy and legislator maker adopted a law. So it's an interesting. Maybe they're going to be. So there's no yet maybe it's going to change, but there's no legal right of action in the AI Act right now. So individuals cannot go ask a judge to make a decision on a high-risk systems, for instance, but that might change. We learned that recently, and so hopefully, even if Swiss people cannot go see a judge to apply the AI Act, they might benefit from the EU proposals. So I think our time is up and coffee is calling. So we're going to take a small break. I think we're coming back in 15 minutes. So around 3:15 with our panel on economics and finance. So thank you very much. A round of applause for our speakers, and see you soon.